Hello, folks in the room and virtually. I'm Danny Waltz. I'm a member of the litigation team at Animal Legal Defense Fund. Welcome to the session titled Rights of Nature and Animals, Advances and Setbacks. Because this is the last panel of the day, we're going to do things a little differently, add some excitement, and run it as a roundtable. This roundtable will discuss current rights of nature and animals cases, including the legal rights of water bodies to exist, flow, be protected against pollution, and maintain a healthy ecosystem, the scope of the Ecuadorian Constitution to protect wild animals, and the future paths for these conversations and approaches to legal advocacy. We'll have time for question and answer at the end of the session after we do some introductory remarks or presentations from each panelist, and then hold the roundtable discussion. Each presenter will open with 5 minutes of remarks, and then we'll move into questions that I'll start with, but then we'll open it to the rest of the group. In this order, we'll start with Chuck O'Neill, Marcia Condoy, and Randy Abate. I should mention who they are. Chuck O'Neill is president of Speak Up Wekiva Incorporated. Marcia Condoy has an LLM in animal law from Lewis and Clark and is promoting animal rights advocacy in Peru. And Professor Abate is the assistant dean for environmental law studies at the George Washington University Law School. We'll start with Chuck.
Thank you so much, Danny. And thank you to the organizers for inviting me to come here tonight or today and talk to you on this great, cool Saturday afternoon in Washington, D.C. We're going to start with a little slideshow here. And this will give you an idea of why they invited me, why I'm here, and what my relationship is with the rights of nature. If you look at the state of Florida from a hydrological perspective, it almost looks like a living organism with arteries and veins. This is a closer look. And if you see the right down the center of the state going north to south, there's a black line there. And that's the Lake Wales Ridge. That's the high point, and that's kind of the spine of the state of Florida. So water that falls east of that spine runs to the Atlantic Ocean, and what falls west runs into the Gulf of Mexico. And as it runs through that path, it picks up nutrients, which were also known as nitrates and phosphates that come from animal farms. It comes from septic tanks, comes from lawn fertilizer, and it moves through those arteries and veins towards both coasts. And one of the problems is when you overload those waterways with nitrates and phosphates, here we see a river outflowing into the Gulf of Mexico. It takes these nutrients into the water. And in the case of the Gulf of Mexico, it's feeding red tide, which is toxic to animal life. Also, as it gets closer to the coast, when it gets into canals, it forms and feeds cyanobacteria, which is also known as blue-green algae. But even though it's called blue-green algae, it's not algae at all. It's a bacteria, and it forms in mats that is toxic to marine life. When it begins to die, when it reaches the coast and reaches salt water, the cyanobacteria begins to die. And as it dies, it draws oxygen from the water. And it actually depletes the oxygen to the point where the fish suffocate in the water. And you can see these mats of dead fish. Also, for instance, in the Indian River Lagoon, which is near the east coast of Florida, last year, over 1,000 manatees died because the algae forms so thick that it blocks the sunlight from aquatic plants. So the plants die and there's nothing for the the manatees to eat. So to try to address this problem, and I don't claim to be an expert on the rights of nature. I'm a person who met Mr. Thomas Lindsay here back in 2013, who heard him speak. And back at that time, I thought the rights of nature is just too radical an idea for the state of Florida. Now, all of you know that the state of Florida is one of the most progressive states in the nation. And our governor is one of the most progressive governors in the nation. But that aside, I figured too radical until 2018, when we had these horrible marine mammal die-offs, fish kills, and most importantly, the property values along the coast. The property values of people like Senator Rick Scott, who's on the coast. When you have mounds and mounds of dead fish piling up on your property, well, that might be a key to moving forward. So I invited Thomas to come to our house. This is my lovely wife up front here, Doris. I invited him to come to our house, and I invited 25 activists from around the state, people I had known for years, to come and listen to him. And he explained to us why everything that we were doing up to that point was not working. Everything that we were doing up to that point was involving contesting permits, contesting a permit to pollute. And what he taught us was that system is doomed to fail for the advocates. It's set up to fail because the criteria that these permits are issued under are so low, the bar is so low that the applicants for polluting permits almost always get the permit. And if you're possibly able to stop that permit, it gets pulled, they revise it, and it comes back. I can tell I'm going to go over here. So this group got together and we formed what's called the Florida Rights of Nature Network. And what we tried to do here is drive through local law, the rights of nature, into Florida law. And there are three ways to do it. Through a county commission can place an initiative on a ballot to amend the charter. Citizens can get together and sign petitions. Or the third way is a charter review commission. So in Orange County, we were able to get the charter review commission, a charter being like a constitution for a county. We were able to get them to put this on the ballot. And what it did was it gave rights to all the waters within the boundaries of Orange County. The rights, as Danny said, the rights to exist, to flow, to be protected against pollution, and to maintain a healthy ecosystem. This went on the ballot in November of 2020. And amazingly enough, in one of the most contentious elections of our time, was able to get 89.22% of the vote, which is still amazing. So now that we had this law, the next thing to do was to try to enforce it. So we filed a lawsuit against a developer who was filling in over 100 acres of wetlands, which are Florida's kidneys in keeping our waters clean. Immediately upon this, the CRC passing this measure to get onto the ballot, the Florida legislature, at the behest of the Florida Farm Bureau and others, passed a preemption bill that said that no local government could recognize the rights of a plant, animal, or body of water. But we argued that the Florida Constitution said that adequate provision shall be made by law for the abatement of air and water pollution, and that overrode Senate Bill 712. We said adequate provision. How can you possibly say that adequate provision is being made for the abatement of water pollution when 1,000 manatees are dying a year? The judge's ruling in this case, there was a motion to dismiss, and the judge, who's appointed by the governor, our very progressive governor, said that the court has no power whatsoever to change or alter the wording of the legislature. They had no power. So all that we learned in civics about checks and balances is wrong. You know, what can you do? She had no power. She's only a circuit court judge. What can she do? And so what we've done is we have appealed that ruling, and probably later this year, we'll go in front of the appellate court. And the question is, in reading the synopsis of this panel, was the setbacks. It was as a setback. I don't see it as a setback. I see it as something akin, but not equal to Susan B. Anthony being arrested for voting while being a woman, or John Lewis being hit over the head trying to cross a bridge. This is a natural evolutionary process that you're going to be rejected because the system will reject something new that comes in. And that is exactly what's happening with the rights of nature today. Thank you so much.
Thank you, Chuck. And now we'll hear from Marcia.
Well, I don't know how can I see my slides, but hello everybody. My name is Marcia Condoy. I'm very happy for having me here, for being here, and thank you so much to the organizers for having me here again. Well, I don't know how can I present. Okay. Well, today we will talk about rights of nature and how it's related with animal rights. And I want to present my perspectives of that, mostly from my Latin American experience and also from the constitutional experience from Ecuador. So we know that in 2008, for the first time in the constitutional tradition, Ecuador enacted a new constitution with rights of nature. And Article 10 declares nature, or Pachamama, as rights holder, but only in relation to the rights that the Constitution recognized for it. And these are the rights: the right to integral respect of its existence, the right to maintenance and regeneration, and the right to be restored. It's important to say too, as a background, that this recognition of the rights of nature was done by the government with the intention to have more acceptance and more support from the citizenship and from the citizens. And you will see why. Because first, the goals, rights of nature has the goal for overcoming the Western hegemonic worldview, because native communities are asking for the recognition of their worldviews. And also because in Latin America, we have the sensation that transnational corporations or foreign corporations are taking our natural resources. So obviously, with rights of nature, we want to overcome this capitalist society. We want to overcome this the extraction of natural resources for abroad. So, in the Constitution of Ecuador, Pachamama, or nature, is defined as the place where life is reproduced and occurs. And for that reason, initially, nature was understood as a place, mountains, rivers, etc. And progressively, we began to introduce new subjects, and animals were understood only as a species, until the Estrellita case. This January 2022, for first time, the Constitutional Court of Ecuador, that is the most important court whose decisions are binding precedent, recognized that rights of nature in Ecuador also protects individual animals. And the argumentation was like this: because we want to protect nature, we want to protect species. And because species are made from individuals, we have to protect individual animals. And that is a good argumentation. It's very well constructed. And of course, this decision recognized as a consequence that animals, individual animals, are persons, legal persons and rights holders. Given the importance for rights of nature of the Ecuadorian Constitution, and also from the importance of the Estrellita case for animal rights, for me it's very important that we take these two documents and identify what are the advantage and disadvantage. And this is very important because we can not only say that Ecuador is the first country with rights for animals, only without making a critical reading, a critical analysis of these documents. And we will talk in this panel about this in a more detailed way. But for me, for instance, an advantage of rights of nature is the instrumental value, because rights of nature takes legal personhood as a tool for environmental protection. Also, because rights of nature gives a legal standing. We will see also that rights of nature puts the rights of nature as constitutional rights. So in a legal system that takes into account the as very, very important the Constitution and the constitutional rights as the foundation of the whole legal system, we will see that nature with rights now can compete better with other legal subjects, that is humans. Other advantage that we can talk about is the symbolic value. From my experience with friends and visiting Ecuador, I can say that the people now is talking about the importance of protecting nature. And also I hear from people without legal education saying that now animals have rights, even when they don't know exactly what does it mean. But also, I identify disadvantages, and this is because rights of nature is inherently environmental. And we will see, and we can discuss with more detail in the panel, that when you make an analysis of the rights of nature, necessarily you will take an ecological point of view, an ecological interpretation. And ecological interpretation means that we have to consider what are the natural processes, what are the symbiosis between species, etc. And just to give an example is that these are the list of rights that the Constitutional Court of Ecuador recognized for wild animals in the Estrellita case. As you can see, we find right to life, the right to health, etc. But all these rights have to be assessed from an ecological interpretation. And the ecological interpretation says things like this. I cannot read exactly from here. I don't know if, for instance, when a predator kills its prey, the right to life of this animal is not violated, rather is part of nature. And immediately after of this paragraph, the court established this, that humans, because humans are omnivorous by nature, we can feed on other animals without problem. So you can see that the rights of animals under the rights of nature have a different interpretation, have a different meaning. We have to make an analysis of these things. Because for me, animals deserve rights with autonomy that give them autonomy, inviolability, intangibility, and it's difficult to achieve this, from my point of view, from the rights of nature. And my argument is that we have to fight again for animals, for obtaining rights for animals with the same legal foundation than rights for humans. So basically is that we can talk about these points in the panel. what kind of rights we want for animals and how we'll achieve that. Thank you.
Thank you, Marcia. And finally, we'll hear from Professor Abate.
Thank you, Danny, and thank you to ALDF for the invitation. It's wonderful to be here. And when people ask where I live these days, I respond by saying I live at the corner of Animal Law Street and Environmental Law Avenue, and that's a great place to live. There's so many exciting developments in these two fields. It's been very much the focus of my teaching and scholarly writing and program building over the past decade. And so it's very exciting to be a part of this panel, appropriately so. And I want to focus my remarks on picking up on some of the things that we've heard earlier today and tie it into some strategic considerations for this panel. So we heard a great presentation from Dr. Lori Marino and the role of sentient science. And I think this is relevant to our panel in an important way, which is, if you've been paying attention for 5 minutes today, we all know that animal protection under the law is very difficult. There are many obstacles to achieving the protections we'd like to see for animals. So one lesson that animal law can derive from environmental law is how important the role of science is to secure that political will and awareness about how these animals need to be protected, because that was very much the driving force of what launched environmental law as a successful movement in the 70s. We were bombarded with very clear science about how pollution was killing us, basically. It was a major public health and safety threat, air, water, hazardous waste, land-based pollution. And so when we have animal science, sentient science advancing the way it is, it's very important for building that awareness, that sense of a desire to respect the integrity of animals and the need for animal law to do everything it can. The challenge, though, is legal personhood has been one of those frameworks to achieve that important protection of animals' rights. And the challenge with legal personhood, one of the many challenges, is the idea that the concept of personhood is a bit of a human construct in the sense that, well, first it includes the word person, and that's a bit of a distraction. But secondly, it's almost like trying to put animal rights into a human rights like box. And that's been a real challenge to overcome. So relevant to this panel, there's another potential box in which animal rights can proceed forward, and it might be more productive. It might be a more effective foothold to secure animal rights compared to legal personhood, and that's going to be part of the discussion we explore a bit more. And so I wanted to pose that might be one way of getting past the floodgates and slippery slope concerns that we've seen in a lot of the litigation involving animal personhood. Another important difference is how legal personhood for animals differs from rights of nature in terms of its legal effect. So in terms of legal personhood, we're looking at a need to advocate on behalf of an animal. A person would need to have standing to do so, and that's been a challenge. And also, there's precedent about needing to appoint appropriate guardians to step in to be the representative of animals when we're talking about legal personhood for animals. On the rights of nature side, it's quite more broad-based, that when rights of nature is declared, there isn't that same standing concern. It is open standing for anyone who is interested to enforce the rights of nature for whatever is being protected through that mechanism. And also, another important distinction between these two constructs for protecting animals would be that legal personhood has been largely fought through the courts, and that's had its challenges. Common law offers some degree of flexibility to try to change the law, but there's been a lot of difficulty in succeeding in the courts, in one case at a time, through many different creative and persistent efforts that we've seen by many of these outstanding animal law organizations. However, when we look at rights of nature, it is largely legislatively driven. It's sometimes constitutionally enshrined. So these are very important legal protections that can be built upon in seeking rights for animals through something that is perhaps a little bit more firmly established in legal recognition than trying to proceed through very creative theories through the courts, one case at a time. Some of those efforts have been successful in legal personhood for animals. A lot of them are outside the US, but nonetheless, the success in the US has been overcoming so many obstacles to get as close as we are in getting those victories. But nonetheless, rights of nature may present that opportunity to get more success overall compared to the legal personhood approach. So we'll explore some of that a bit more in our discussion. Thank you.
Thank you, Randy. So I'm wondering if we can start with we've had great presentations from our first two panelists about very specific examples of how the rights of nature been applied or attempted to be applied. And then Randy took us to an analysis of the difference between legal personhood and rights of nature. And I'm wondering if Marcia and Chuck, if you had any sort of reactions or responses to the distinctions that he was drawing, and see if you have some, we can bring Randy in.
Well, can you hear me? Yeah. Well, I think that it's important to differentiate between when I told about there are direct advantages from rights of nature. I recognize that rights of nature is a big tool for environmental protection. As I told before, you give a personhood to the nature, but also with this personhood, you will give a standing. You will give a standing to people to ask the authorities to act for nature. And also, I think that we can gain a lot for environment. But in a long term, and also from a pure theory perspective and technical legal perspective, there is some problems that we have to put attention. So I think that it's important to have this in mind when we will make an analysis of rights of nature. Only that.
I agree with Randy's perspective. It is difficult, and I'm looking at this from a political standpoint, in getting people to agree and vote for something that gives personhood to animals or bodies of water or plants, because there's something that some type of disconnect there that people have a difficult time. And this also goes to people who are concerned about human rights with this idea of personhood. What I like to see more often is the concept of rights of naturehood, to allow nature to be nature, to allow nature to do its functional capabilities. And I think that's what Marcia really pointed out in her presentation, was that the Ecuadorian court in the Estrelita case said that animals basically have the right to be animals, to be their natural selves in their natural environment. And I'm not sure that personhood, I mean, if you look at what persons are doing around the world, I'm not sure calling anything a person is a positive thing anymore. I think that animals need to be recognized for their own rights, distinct from humans.
Randy, curious if you have any responses to this?
Well, I think it's important to recognize also that humans are the ones making these laws and enforcing these laws. And so when you think about a strategic consideration about what's most likely to succeed in gaining traction for animal protection, it has to be something that fits into that human, non-human relationship in the world. And so there is certainly more attention these days to the importance of protecting ecosystem integrity, because here we are in the climate crisis, in the throes of it in 2022. And one important piece of responding to the climate crisis is cultivating climate resilience. And the most critical factor in promoting climate resilience is intact ecosystems. There's certainly an opportunity to focus on the value of ecosystem integrity as a way of protecting nature and animals collectively as a legal entity, and recognizing that that's different from protecting human rights and human interests. And there's, in many ways, regardless of how much science advances in terms of animal sentience, there's always going to be that divide between how the law protects humans versus how it protects non-humans. So there are some efforts already underway, and ones that have been recognized, that ecosystem personhood is now a new path within the legal personhood domain, where the Colombian Amazon was recognized as having legal personhood as an ecosystem in a climate justice case. And also there's an effort now to get the Great Barrier Reef recognized with legal personhood / rights of nature protections. That's still a work in progress, but these efforts to me seem very promising because it recognizes those inherent interactions between nature and animals, and ultimately could be a win-win for both interests. I'll stop there.
I think it would be helpful for me, at least definitionally. You talk about ecosystem personhood. And to me, that sort of, I'm having a hard time distinguishing that from rights of nature. We heard on the previous panel, very helpful discussion of legal personhood for individual animals. And I can understand the distinction between individual animal personhood, legal personhood, and the rights of nature. But when we start talking about legal personhood for, say, the Great Barrier Reef, I don't see much of a distinction between that and rights of nature. I'm wondering if folks on the panel could help me at least understand what the difference is.
You're right to be confused, because it's still a work in progress, really, in terms of the advocates in Australia that are seeking to protect the Great Barrier Reef are kind of clashing in which approach makes more sense. There are different groups of advocates that are advocating one or the other approach. And I think both approaches face a common concern, which is the Great Barrier Reef is so vast and has so many different interest groups at stake to protect what it represents, ranging from, ecological integrity protection to tourism to fishing and so forth. There are a lot of different interests at stake there. And so it's very difficult to reconcile those with one voice. And then the issue becomes, does it have to be one voice when we're talking about a rights of nature or a ecosystem personhood? I mean, all of these are unanswered questions, but nonetheless are being actively considered now in terms of what it means to protect an ecosystem, and that it's just very unresolved right now. So that effort in Colombia, with the Colombian Amazon being recognized as having a legal personhood as an ecosystem, that was done sua sponte by a court that wasn't even that wasn't even the main question before it. It was a climate justice case brought by youth plaintiffs seeking to compel the Colombian government to reduce deforestation to zero in the Colombian Amazon. And in agreeing with the plaintiffs' efforts to achieve that goal, the court went on to say, and the Colombian Amazon has ecosystem personhood, without further explaining what that really means.
Daniel, are you referring the definition of nature, or how do you individualize, or how do you make an individual of nature? Are you talking about that?
Actually, that's a great segue to another question that I had, which is when we talk about the rights of nature, and if you don't mind answering this first, does it matter how do we define nature? How do we define the nature that we are endowing those rights to? And who gets to define it? For example, can the rights of nature protect domestic animals? Should it protect the hippos of the Magdalena River that we just heard about? If say the rights of nature are endowed to the Magdalena River, and the hippos could be perceived as an invasive species that are altering the ecosystem, do those hippos receive certain rights within the rights of nature framework? I wonder how you define nature when we talk about rights of nature, and who should be the one who defines it.
Yeah. Oh, okay. Yeah, no, what happened is that when you enact a legislation or the constitution, for instance, you have to give the meaning of what is nature. For instance, in Ecuador, the nature is Pachamama, or where the life is reproduced and occurs. It's a very broad definition. But in what happened in this broad definition that makes that appears to be referring to the whole ecosystem, what happened is that the Constitutional Court of Ecuador began to construct a definition, and first it established that it has to be physical places, but determined in specific situations. And for instance, you can say this river is nature, or this mountain is nature, or this endangered species is nature. But at the end of the day, you will see that it's a very arbitrary established definition, because at the end of the day, if you think about this, everything is nature. Even where we are now could be considered nature. So to define what is nature is I think that it will be a legal exercise for courts in the future, in Ecuador in this case. I don't know.
Well, if you talk about, and Danny, you bring up a good point, where when you, let's say you pass a rights of nature law for the river, and then aren't these hippos that were living in the river when the law was passed part of it? Well, if they're classified as a non-native species, then whose right comes first? The right of the river to exist as an ecosystem versus the right of the hippos to life. And I think you have to, there's no easy way or dark line that you can draw between the rights of the individual versus the rights of the ecosystem. And each of these cases needs to be looked at in its own microcosm. So, for instance, the rights of the hippos, are the hippos adversely affecting the ecosystem? Are they destroying the ecosystem? Versus, for instance, the Everglades and the pythons in the Everglades. The pythons are destroying, they're creating large dead zones where they're eating everything around their nests. So in that case, I believe that the right of the ecosystem to exist and all animals within that ecosystem would override the individual rights of the pythons, for instance, to exist.
I think nature would be left for the legislature to define, because it's not an inherently clear term. I think if we had a poll in a group of accountants and a group of animal lawyers and a group of environmental lawyers, you'd had fundamentally different definitions of what nature means. And so that's what the legislature is for, to determine what's within the scope of what should be protected. And then the courts would interpret the extent to which that scope is narrow or broadly construed. And otherwise doing it one court at a time would just be unmanageable and inappropriate.
Can I say something? For instance, I think that it would be a very, very problematic if you give the power to the legislature to say what is nature. Because what is the goal with rights of nature is protect the environment. And the people want, there is a paradox, because people want environmental protection, but also want cell phones. People want more progress and development. So when the people ask for rights of nature or environmental protection, I think that will be very difficult for the legislature to say this will be nature, this area of the forest or this specific river, because everybody wants their rivers to be protected. I think it would be a theme that will be rights of nature, and the definition of nature would be more a theme that courts have to do more than the legislature, from my point of view.
I would like to agree with my friend from Peru here on this. If left to the legislature is largely dominated by industry and commerce, or overly so. The courts, as you mentioned earlier, Randy, the courts are evolving this idea of the rights of nature at a much faster pace than the legislatures. As you mentioned, there are courts that are coming up with advances that were never even a law on the county level. For instance, in Bangladesh, the Bangladesh High Court ruled that all rivers in Bangladesh have rights. And this is something that is progressing. Now, on the legislative front, just this week, September 21st, I believe, the Mars Menor in Spain acquired legal personhood. So these things are happening in the courts largely, and outside of the courts in public discourse and in the evolution of the rights of nature.
So I guess one last building blocks question, which you've started to touch on, but what I've heard so far is there are various ways in which rights of nature have been created through the legislature, through Chuck, I think your presentation talked about ballot initiative, and then Randy, you were just mentioning a Colombian court decision, so it also can arise through the courts. I'm wondering if y'all, if whoever feels comfortable to do this, could create some sort of categorization about the various ways in which rights of nature can be created, and then I'm curious to hear from all three of you what is the preferred way to do that and why.
I would say that,
and maybe one question is also, does one method of being created allow for easier enforcement, stronger enforcement, and actual real protections?
in the United States, we have this hierarchy of local law basically being underneath state law, which is underneath federal law. And so this hierarchy makes it difficult to advance the rights of nature from the bottom up, because as we've seen in several states, when a local initiative begins, the state steps in and writes a preemption and passes it, which only leaves a citizen's initiative to change the constitution in that state as an option. So
if with 89% success rate, though, maybe that's worth pursuing.
You know, it's odd that you would have a legislature comprised of people who were elected with maybe 51% of the vote or 52% of the vote that have more voice than 89% of the voters. And as that continues to happen, how long can they ignore the will of the voters when it's so clear what the voters want? And I think we're going to start seeing the effect of that in elections, whether they be local or statewide. And maybe that's the point at which sometime you'll see all of a sudden the most ardent opponent for rights of nature all of a sudden become the most ardent proponent for rights of nature.
Yeah, well, I can talk about the Latin American perspective. I think that it will be very difficult to enact this in the legislature, in the Congress, because there are a lot of lobby for corporations. It could be easy to talk about constitutional new constitutions. In Latin America, we are changing constitutions maybe with every 20 years. So it's very, very easy by that way. Also, our courts have a lot of flexibility to recognize new rights. What happened, for instance, in Colombia is that they recognize the rights of nature for the Atrato River. But it's important to say that they didn't recognize these rights of nature for the Atrato River only because rights of nature, rather because the Constitutional Court used a concept that is very interesting, that the name is biocultural rights. That they use the biocultural rights, that is the cosmovision and the worldviews of the native communities that give life, they consider that a river has life and is a person, and they use these biocultural rights to recognize rights of nature. And now we have by the path of the case law, of the constitutional case law, we have rights of nature in Colombia. So there are different paths that we can take, because the decisions of the Constitutional Court in Colombia are binding. So it's like law. It's even more hierarchically more than the law. The law of the Congress. But the question is, what are the legitimacy of the recognition of the courts? Because traditionally, we know that the only entity that can enact new laws is the Congress. So there is a big discussion about if courts really can create new rights. So there are different things to assess in this way, but I think that in the case of Latin America, the use of the constitutional courts and constitutional tribunals are very important, even more powerful than the Congress.
I really see rights of nature as a means to an end, and as perhaps an evolution, as Chuck had on one of his last slides, in that it's a way of raising the profile of how animal rights can be considered, but not necessarily the way in which it's ultimately going to be achieved most effectively. And so again, taking a page out of the environmental movement's playbook, it's important to remember that for nearly 2 centuries in the US, environmental regulation was happening at the state and local levels exclusively. And then this massive revolution in the 1970s, with the science supporting the threat, public health and safety threat to human health, all of a sudden we had this robust, literally in the blink of an eye, robust federal environmental law regulatory system. The same kind of revolution can happen with animal law. It's important for us to always reflect that, we have an environmental protection agency. Why don't we have an animal protection agency that could serve a similar role? And ultimately, when we look at what's going on with climate change litigation and climate justice litigation right now, there are a lot of rights-based approaches that are gaining some traction and raising awareness about the importance of climate justice. But ultimately, the theories that are having most success and are most likely to make that paradigm shift are the ones that are seeking to compel, and sometimes succeeding in compelling, the government to raise its ambition in protecting the public regarding how it's regulating climate change. So that I see as really the end game for animal protection, to somehow simulate that paradigm shift to federal regulation of animals on the basis of welfare and rights, in much the way that we see with environmental protection. And that's going to be a process. It likely won't happen as fast as it did with environmental law, but ultimately the rights-based approaches, whether it be legal personhood or rights of nature, are a step in that journey, but not the end game.
Yeah. So jumping off of that, does the rights of nature framework do anything for individual animals? From an animal rights perspective, does the rights of nature, I guess, so Randy, you've intimated that, yes, it's a step in that direction. I'm wondering if panelists agree, or whether they think it's a sort of wrong turn on the way towards protections for individual animals.
Well, I feel I'm an expert because I read Marcia's white paper on this matter, which is an excellent white paper. And what it did say that the court in the Estrelita case said was that animals have a right to protection as individuals, not just as species. So the fact that an animal is not a member of an endangered species is not an ultimate qualifier as to whether it deserves protection under that law. And the fact that animals were recognized under the Ecuadorian Constitution as being rights-holding entities, and that individuals could act as guardians for those individual animals, which of course is completely necessary, as you have to have a person to act in the stead of the animal in court. So I do see that the rights of nature is acknowledging the rights of individuals, not just species or ecosystems.
Yeah, I think that there are we have to make an analysis in relation to the situation in which we are. For instance, in the constitutional case of Estrellita, that is very popular because, of course, it was very successful for an individual animal. Why? Because Estrellita is from an endangered species and is a wild animal. So obviously the connection with rights of nature is very evident, and you can say, yes, that animal has rights because it's an individual animal important for this group of monkeys, and this group of monkeys is part of the patrimony, natural patrimony and natural rich resources of Ecuador. But my concern is, I have different concerns, but for instance, what are the foundation when we will assess rights? We will say this entity has rights, but why? In the case of humans, for instance, is because we have dignity. Is the base of all the rights. No, we have right to life, right to freedom, right to physical integrity because you have dignity. And dignity is because you are a human being. And in the case with rights of nature, the foundation is environmental protection. So obviously you will protect the right to life of a monkey because without that monkey, you are putting in danger the whole species. But, and this is what I was talking I was talking in the presentation, is that all the time you have to have in mind with rights of nature that you have to have an environmental perspective, and you have to take care of what? Of the natural symbiosis. You have to take care of biological interactions, that you will not move an animal from here to here because you are creating you are damaging the balance, the natural balance, etc. So at the end of the day, you are taking the animals as part of the species. And to make an argument that you have to protect, for instance, a monkey and keep the monkey in that house with that people, as in the case of Estrellita. I don't know if you know the case of Estrellita, but Estrellita was living with a family, and this family was taking Estrellita for 20 years in a house with clothes, with an own room, with treating the animal as a child. So it's difficult. It would be very difficult to say, okay, on the rights of nature, how that family, how Estrellita have the right to have a family, because at the end of the day, that humans were the family of Estrellita. So that was a problem. And also because more than when I told that the foundation of the rights of nature is environment, is the environmental protection. What I think that we have to look for animals is rights with a different foundation. That is the foundation of dignity and also autonomy. And also because these kind of rights that derives from dignity, from autonomy, that takes the subject as individual, what the effect of these rights is create a sphere of protection against everything. For instance, nobody can touch my body. Nobody can consider me as food. Nobody can take me arbitrarily to jail, for instance. And that is not happening with the rights of nature, because as I mentioned in the presentation, the same court is recognizing that animals are eating one each other, that we are eating animals, and that is natural. And yes, of course, it's natural, but not because it's natural, that means that it's correct. And yeah, that is my conclusion.
Yeah, and I respectfully disagree. So I really have a lot of respect for Marcia's views here that, ultimately the goal of animal law is to enhance that protection and respect for individual animals and not merely as a part of a species and an ecosystem. But that's not going to happen overnight. These are very slow cultural and legal shifts that have to happen. And I think the outcome of the Estrelita case is very positive for the animal rights movement because it's raising the profile and status of animals as a subject of protection under the law. And yeah, I wish the outcome of the case also meant that we can't eat animals starting tomorrow, but that's a lot to happen in one legal decision. So I think this kind of outcome can inspire related initiatives based on that political will, awareness building that the case does create. And I just saw this week that a city in Switzerland is seeking to ban factory farming. So, I mean, the value of these decisions on a case-by-case basis, even though they aren't getting the ultimate outcome that animal rights activists may want, it's that secondary impact in the court of public opinion that matters more, that will ultimately advance the outcomes that the animal rights movement is seeking. And there's just a high degree of patience that demands, that it's not going to get the outcomes that are sought immediately. There's going to have to be this kind of incremental process of getting there, and piggybacking on environmental outcomes that are first and foremost environmental, secondarily for animals, are still victories. And it's difficult to keep that long view in perspective, but I think that's going to be really important because there are a lot of ways that animal rights can piggyback on environmental successes.
Marcia, in your paper, you talked about the core ruling said that even in that ruling, they said this is not the be-all end-all of the interpretation of the constitutional rights now of animals, that this is going to be an evolutionary process through other rulings, through other courts' interpretations. And I think that's, what we're trying to do here is to create a framework where the law can evolve to get to a point where the rights of individual animals, where they do have that dignity. But, this is, at least here in the United States, it is a very difficult task when you're up against a society that has looked at animals as objects since its inception. And the hope that I have for the rights of nature is that it is a catalyst for understanding that animals should be viewed as having their own rights, their own right to life, and that we evolve into a more just society, which is this I hope is a start of that. And the fact that we're here on a Saturday afternoon and have such a great audience and folks online listening to this, I think it's very, very encouraging, at least to me, that this is what's happening, that it's happening not just here in the United States, but it's happening all over the world in small places and large places, in courts and in legislatures.
On that positive note, yes, Randy.
I just have a footnote to that as an example of how slow this progress can be from the environmental movement's perspective. It took over 10 years of advocacy to get one sentence in the Paris Agreement that says climate change has human rights implications. Doesn't seem like much of a victory, especially since it comes with no enforcement mechanism. But that sentence was considered a major victory for the climate justice movement, because now there's lots of positioning to seek the accountability that comes from that initial foot in the door, or paw in the door, as it were, to really build on that initial step forward. And it shouldn't take that long, and it shouldn't have to proceed so incrementally. But I can assure you, within the next 5 years, you're going to see human rights-based accountability for climate harm against governments. And that would have been unthinkable 10 years ago.
If we could open this up to audience questions. Right.
Hi, thank you. I'm always troubled by arguments that about invasive species that appeal to rights of nature, because the fact is, can you really make the argument that pythons in Florida should be thrown under the bus because there's a right of the ecosystem or the other species to live? I mean, without really straying from a pure or consistent definition of right to life for any animal.
Yeah, and I don't think this is an easy question at all. If you value the rights of the lives of the animals that are being eaten, that were in that ecosystem previously, let's say native animals, and then you introduce an animal into that ecosystem that has abilities to conquer and kill everything within that ecosystem. This is not an easy question at all. And I think, in agreement with you, it's taken too lightly by governmental organizations, in this case, the Florida Wildlife Commission, to act as God and say all creatures in that species can be killed on site. And they actually make a game of it, who can get the most of it, which is antithetical to any consistency with justice. So it's a very difficult question, and one that I think we had an argument about before this panel even met in person online. So yeah, it's not an easy question at all. I agree.
Yeah, indeed, the Constitutional Court in the Estrellita case told that. After what I read, that humans can eat animals without problem, he told even we can continue having wild animals for in situ conservation, zoos. Also, he told we can have we can continue fighting against invasive species, so we can kill invasive species. So as I told, it's very problematic, because you all the time are thinking how you will maintain the ecological balance. And of course that an endangered species, an invasive species is putting in danger the ecological balance. So for that reason, I arrived to the conclusion that on the rights of nature, the rights of animals are totally different, are very legally different from the rights of humans. So we have the rights the right to life of a wild animal, and we have the right to life of a human being, and they work very differently. So we continue having this barrier between humans and nature. So yeah.
Danny, if I can add, there's a fair compromise that's difficult and expensive to this situation that I think upholds both rights of animals and rights of nature perspectives, and that would be humane removal of the pythons in a way that is going to be respectful of the individual invasive species who did not decide to go on vacation. Hey, I hear the Everglades is a great place to crash. Let's go. I mean, these are innocent creatures who were disposed of there, somehow made it there, not of their own choosing. And then you've got the existing species and ecosystems that are being terrorized by their presence also need to be respected, so that the win-win is to just get them out of there and into a safe location where they're native, and will not be causing those threats. And of course, that's expensive and difficult and inconvenient. Similar situation came up when Chicago, unlike also in DC, a massive rat infestation. And of course, the initial response, gut level response, is to just exterminate them. They're a pest. They're causing all these safety and health threats. But ultimately, the humane approach that actually worked was to sterilize rather than exterminate the rats. And again, there's a way to address invasive species problems that are respectful of individual invaders and also ecosystem and health and safety concerns.
If I could just follow up with that, Randy, does the rights of nature framework help with this, or does that hurt with this? So if that's the solution, I guess the question is who is making the decision on how to deal with invasive species, and does the rights of nature framework authorize or enable the appropriate decision makers to come to your proposed solution or a different one?
Yeah, that was a solution that really existed before the rights of nature overlay. So that I'm not sure that the rights of nature, it changes that outcome, but in terms of whose decision it is, that's a very difficult question that I don't have an answer to. But ultimately, rights of nature really just kind of represents that ecosystem interest on one side, and how that's ultimately going to be protected, and whose decision it is, I think, is a next step in that discussion.
Sorry, I cut you off.
Thank you for the very insightful analysis. I'd like to ask if we maybe are not coming to this from too narrow a focus, because both the rights of nature and the animal rights approaches seem to have significant limitations. So maybe we should ask, what are we protecting against? And can we look at legal reforms to change the way the pressure is being applied to our natural ecosystem? So I'm thinking, we obviously exist in a system of free market global capitalism for the most part around the world. And that system has been very adept at accumulating wealth from essentially a linear process, and all of our metrics reinforce that, like GDP and so on. So we have the cost and benefit of our economic systems are separated both in time and geography. And institutions like the multinational corporation enable that, and they remove decision makers from public accountability at local levels. So if we're going to look to develop a new rights-based mechanism to protect both individual animals and species, we must address where is the problem coming from. Maybe it's time to look, for example, at the institution of the corporation and say, yes, it was appropriate at a certain time of economic development because it stimulates entrepreneurship, it protects innovators, but is a global corporation still the appropriate way to organize our economic affairs, because it provides a disproportionate amount of power to those that are seeking to exploit the natural environment, and it disempowers the local communities who are struggling to resist the effects. And so when we think about new rights paradigms to protect both animals and environment, we mustn't only look to be defensive. We've got basically trying to stop water flowing downhill, and we need to look at that economic system and say, can we reform that in ways that is politically palatable, but also remove some of the protections that are given to those institutions, which are in fact causing these problems in the first place. So maybe we could think about it from all different perspectives, which would give us a consolidated way of protecting the environment by removing some of the incentives at the other end to destroy the environment and harm the animals in the first place. I'd be interested in your thoughts on that.
Yeah, that is a big critique to rights of nature, because we are trying to protect nature, but at the same time, for instance, again, the Constitution of Ecuador has the rights of nature, like 4 different articles for rights of nature, but after you have the economic rights of the population. So how are you trying to conciliate and to make a work together rights of nature and the right to development, the right to food, the right to water? That is a big question. I think that we have to come back to the idea to ask for to have. I cannot say if we need rights of nature or not. I prefer to avoid this topic because I am not an environmental expert. I think that from my point of view, we have to fight for human rights, and in the Constitution also rights for animals with the same foundation as I told, and we can have rights of nature. But from my point of view, the rights of animals cannot depend from rights of nature. And yeah, I don't know if that answered your question. It's very, as I thought, we have to think, we can be thinking to discuss after maybe, how are we trying? Because when I say we have the right to social and economic rights, I am not saying only that we have the right to have a cell phone, that the people in Latin America have the same right to have hot water in their houses as in the United States. We don't have that kind of culture, but everybody wants these kind of things. Everybody wants development. Everybody wants a lot of water in their houses. Everybody wants cell phones, computers, etc. But at the same time, want environmental protection. And I think that we have to, and for that reason, there are academic people who say that the rights of nature in Ecuador is not really a very big change in the system, in the political system. Indeed, it's more a declarative thing. It's more has a political value, but structurally, we cannot ask yet, maybe. We are a society, we are not mature to ask real rights for nature. Because, as I say, we want a lot of things in our lives.
If you look at what we did in Orange County, which is create a law that gave rights to water bodies, and then use that law to bring an action against the developer destroying those water bodies. That's probably the closest answer I could give to your question. The case was Wild Cypress Branch, which is a wetland stream, versus Beachline South Residential, who was a developer. So in this case, the water body was suing the corporation for damages that the corporation intended to do to the water body. And until you address your question in a real manner, that nature can bring an action in court against some corporation that's doing damage to it, will the corporation respond to pull back and limit the damage that it does to nature? So I think that's an essential component to the rights of nature.
And I think your question speaks to how a rights-based approach by itself is inadequate. So this, again, looking at the climate justice movement, the famous Juliana case really took two approaches, a rights-based approach and enhancing government stewardship approach to address this massive problem about how corporations are wreaking havoc on the environment and the climate. So I think in this case, it would be as easy as it is to blame corporate America for a lot of the harm that the environment and animals sustain. Ultimately, their partner in crime is the government for not adequately regulating their activities in a way that would protect and uphold these rights that we're trying to advance. And so in that case, it was really both, dual jets of advocacy for enhanced stewardship of the government managing our atmosphere, and also an argument that we have a constitutional right to a stable climate. And those two working together, I think, are going to be better than one without the other. And I think that's another way in which animals can get more rights-based protections, is if we're always thinking about the government stewardship piece as much as we're thinking about that individual rights to higher level of protection for animals.
Great, thank you. We've been having too much fun. We've gone long, which always happens, I guess, when you start to attack corporations and their stranglehold on the federal government. So I want to thank the panelists for a challenging and fun conversation, and for the audience for participating in it.